First, thanks everyone for coming today, both in person and online. But as we get started, just quickly, my name is Fry Warnick. I'm a partner in both the Washington, D.C. and Dallas offices at B&E. I'll do formal introductions in a second. Running through housekeeping measures, one thing is we'd love for this to be a conversation. We're going to try to be as conversational as we can to talk about FCPA and white-collar enforcement, what to expect in the coming years under the Trump administration. So with that, let's get started. I'll just kind of quickly introduce ourselves. As I said, my name is Fry Warnick. I'm a partner in both D.C. and Dallas. I was actually in D.C. for 17 years, 11 of which I spent at the Department of Justice. I was a federal prosecutor working on both, everything from guns and drugs to violent crimes to domestic corruption and financial crimes, and then spent the last 5 years with the Department of Justice Criminal Fraud Section, where I was supervisor of the FCPA unit. That's the Foreign Corrupt Practices Act unit, handling international corruption and money laundering cases. I was there through 2019. It was probably one of the most robust periods of enforcement, which we'll discuss during that time frame. And then I joined Vincent & Elkins, and I was with B&E. I was located in D.C. for 3 years before moving back to Dallas, where I grew up, and now I split time. So I'll be in D.C. next week, for example. But great to be here with you. And I'm here joined by Brian and Pete. They'll introduce themselves. We work very closely on a lot of the white-collar matters together. So Brian, why don't you go ahead?
Yeah, thanks, Fry. So my name is Brian Howard. I'm a counsel in V&E's Washington, D.C. office. I've been with V&E for about 12 years. Anti-corruption and money laundering is the largest part of my practice and has been almost that entire time. So I represent a lot of company investigations, advocacy before the government, regulatory agencies, et cetera. I also lead the M&A component of our group, and so corporate diligence and those sorts of things. I evaluate compliance. I help set up compliance programs, and then I also evaluate them on the other side during transactions and the like. Pete?
And then, hi, I'm Pete Thomas. I'm a senior associate with the firm. I've been here for 6.5 years now, started right after law school. I'm also in our government enforcement and white-collar defense group, and like Fry said, do a lot of work with him and Brian, so ditto to what they both just said.
All right. So today, what we're going to cover is basically, this is the agenda. We're going to start with an overview of white-collar and FCPA enforcement. We're going to talk through just historical trends. When we initially scheduled this presentation, it was right after what you learn about the FCPA pause that was imposed by President Trump's executive order. And that was really going to be what we talked about. Fortunately for all of us, DOJ released guidance on May 12th with the new white-collar criminal enforcement priorities. And that is a real good roadmap for companies now to think through what do they need to be looking at. So we're going to spend time talking about the FCPA side. We're still going to do that. It's been a major focus of corporate criminal and civil enforcement over the last several years. But we're also now going to talk a good deal about the May 12th policy guidance that came forward. And there were 4 specific policy features there. The overarching policy memo that came out from the head of the criminal division, the changes to the corporate enforcement self-disclosure policy, updated whistleblower policy, and the monitor selection policy. So we'll spend some time talking on each of those. And then the major takeaways for companies, how this should impact compliance programs and how companies should now be thinking about compliance under the Trump administration. And I think we've identified some opportunities also for proactive engagement to think through, are there opportunities that exist now that maybe didn't exist in previous administrations, not just in the Biden administration, but also the first Trump administration and DOJ just historically. And then, as I said, we'll have time for some Q&A. So we would talk through just an overview here. There have been really major changes. I mean, this should be no surprise to anybody paying attention, watching the news, but President Trump, campaigned on issues like going after cartels, going after immigration, and terrorism, the fentanyl crisis, and really taking these things head on. And so that has been a major thrust of the first 120 days or so of the Trump administration. You see a lot of resource shifting from Washington, D.C. to the field, to the U.S. Attorney's offices more generally. That actually isn't all that unusual under a Republican versus Democrat administration. But here you see also big shifts into the immigration, and combating illegal immigration and the flow of human and drug trafficking across the border. Before May 12th's guidance, I think there was a big question mark hanging over what is white-collar enforcement going to look like? Is there going to be any emphasis on white-collar enforcement? For example, there were reports that the criminal fraud section, where I used to be, there are 3 units: healthcare, the market manipulation section, MIMIF, and also the FCPA unit. Well, there were some reports that the MIMF unit would no longer be looking at securities fraud cases, that actually those would now be just handled out of SDNY's office, the Southern District of New York. There were reports, and this was confirmed, that the corporate crime unit that had been stood up under the National Security Division had actually been was going to be disbanded. And what does that mean? They're no longer going to be corporate cases, for example, for sanctions violations or export controls violations, which NSD had taken the lead on, or CFIUS or FARA type of cases. Healthcare fraud did appear to remain a priority. Same with procurement fraud, and we'll talk about that. But resources did appear to be reallocated. And talking to people I know in DC who are very much plugged in, they were saying, yes, people are being reassigned out of the section. They're getting opportunities to move on to other areas in federal criminal enforcement. On top of that, issues of, what is SEC enforcement going to look like as well? So then, all of this is happening over the last 4 months. And then on top of that, FCPA enforcement, was going to be significantly curtailed. The first glimpse into what would happen under the FCPA occurred on February 5th. And just a little bit of background here, and we'll talk about the historical trends, but the first Trump administration was actually surprisingly robust. And so when asked early on, by journalists, what do I think was going to happen with FCPA enforcement under Trump 2, there was no reason to think it would be any different than Trump 1. Okay, this is a law, it's on the books, and it will just be investigated and prosecuted as normal. But when the February 5th Bondi memo came out, and Brian, I know will speak to some of these issues in a moment, that was the first glimpse that, okay, this is going to be potentially curtailed significantly in how foreign corruption is going to be enforced. And so we'll talk about that in more detail in a moment. Similarly with the Trump executive order issuing a pause for 180 days on all enforcement activity as a strategic review takes place in a way to make the FCPA more of a strategic tool to advance a foreign policy, America First foreign policy agenda. And one other things we saw early on, U.S. attorneys' offices were going to get more responsibility, more autonomy in bringing these cases, which had historically always had to go through the FCPA unit. And then we'll talk through, as people tried to read the tea leaves, what did it mean for FCPA enforcement, the differing ways that what appear to be similarly situated cases were being handled by different U.S. attorneys' offices over the last several months when they had an FCPA or money laundering component to them. And throughout all this, no direct guidance on the SEC was public, but Chairman Atkins had said, we're going to basically follow DOJ's lead in how FCPA enforcement is handled. Then we see the first real insight on what is DOJ's policy going to look like on May 12th. And as I said, there's a number of policy memoranda that are issued, and we're going to talk through what that means for companies and people in this room, people attending online. Before we do so, I think the context of FCPA enforcement is going to be important. And so we want to talk through the history of FCPA enforcement and really get some recent trend lines. And the reason is this has become, if you looked at the last 15 years, probably the most critical tool by federal prosecutors on corporate enforcement. And it has had real changes. Compliance programs have really taken note, have been built up significantly to monitor particularly activity in, transactions in emerging markets, but also counterparties. What are they doing and who are they working with? Because we don't want to have the reputational harm or get caught up into what can be very expensive and lengthy investigations. If I take a step back, I assume most people paying attention who are attending and in the room now know something about the FCPA, but just broadly speaking, that law now been on the books for since 1977, so 48 years. It is the world's first foreign bribery law, and it has the three provisions of the law are the anti-bribery provisions, so you can't pay anything of value to a foreign official. Those are defined broadly, not just elected officials, but procurement officials, people who work for state-owned entities, essentially. But there are also the accounting provisions, the books and records provisions, and the internal controls provisions, which make sure that books and records and controls are in place to guard against bribes being paid. The law was passed in the aftermath of the Watergate scandal. There were a number of hearings at the time, and then there was this discovery that publicly traded companies kept slush funds, and they kept those slush funds to bribe foreign officials, and that then led to this law being passed. And since then, 180 countries or so have signed the UN Convention Against Corruption. The OECD has 40-plus member states, each of which have agreed to take action passing and implementing foreign bribery measures. So there's been a real cascade and momentum in this space over the last 48 years. And essentially, the law was designed to ensure a level playing field for companies operating in markets. It's to protect the integrity of the marketplace. Having said all of that, for 30 years or so, that law was rarely enforced. I think there were approximately 200 cases total by DOJ and the SEC over those 30 years, and amounted to a total of about $50 million in total fines. And we'll contrast that in a moment. But what this slide is showing you is what's really significant is the spike that occurs in the last 15 years. And we have an initial spike in the 2008-9 timeframe, and this graph is showing you just in terms of total actions. The next slide we'll talk about dollar amounts. And what is significant here is that large growth section of 2017 to 2020, and that is the first Trump administration, where you really have a huge uptick in enforcement and sustained enforcement. This slide actually then now gets to total dollar amount and global penalties. So I mentioned a moment ago, in the first 30 years, you had $50 million in FCPA fines going to the SEC and DOJ. In the last 10 years, over $25 billion. So that is, I think, a 500-time increase and a huge spike. And this number tries to give you some perspective. This graph gives you a perspective on what that looks like when graphed out through that time frame. The interesting feature, there's a number of reasons why this was. I know when I was in the office, we had training sessions really to develop close informal ties with foreign prosecutors and authorities to allow for informal information sharing, for referral networks to occur. And so, for example, in 2018, DOJ and the SEC hosted 45 countries for an anti-corruption training. 200 prosecutors from around the world came in and developed those types of ties that then led to actual results and sharing of information. But most importantly, if you look at that third bullet there, 14 billion, I think it's actually higher than that now, shared with foreign enforcement agencies. So if you look at the 25 billion or so in global enforcement actions in the last decade, more than half actually money that was going to Brazil, to the UK, to any number of different countries, France, in connection with cases that were brought together. And sometimes upwards of 80 or 90% of the fine amounts that were taken would end up going to, for example, Brazil in the Operation Car Wash cases. 75% went to the UK in connection with the joint Rolls-Royce investigation that occurred. 50% to the Netherlands in the Wimpelcom or MTS cases. Or Telia cases, excuse me. All of which is to say that was a huge incentive for other countries to cooperate. They were obligated to cooperate under the various treaty obligations that existed. But when they knew that if they helped bring a case that those countries could also receive real financial benefits, that incentivized that enforcement spike. And that occurred up to and well through the Trump years. Now, what we saw over the last few years was a relative lag. And this was somewhat surprising given the fact that the Biden administration had called foreign corruption a national security interest and marked it as such. Now, part of that lag is obviously a result of COVID. For a couple of years, FBI agents were not knocking on doors. The ability to cooperate and be on the ground building cases internationally was substantially curtailed. But also, I think part of it was because this was such a national security emphasis. One of the reasons, this law was never a priority under the first Trump administration, but what that meant was, in practice, prosecutors were able to build cases without the level of oversight and, I would say, kind of micromanaging of the cases from the DOJ front office. You followed the evidence, you brought the case, and also it was a big significant uptick in individual prosecutions, which then made it easier to go after companies. If a corporate employee has pleaded guilty or has been found guilty of a crime, the company, just by virtue of agency law, criminal agency law, has very little defenses available at that stage. And so the DOJ and the SEC became a lot better at bringing those cases, building those cases, and with less kind of political involvement, because it wasn't a priority. Here, what was conversely the case, a lot of people argue, over the last few years under the Biden administration, every time there was a major attempt to bring a big case, there were delays because more and more people wanted to have their fingers on it, make sure it was aligned with what their national security objectives were. Those are some arguments as to potentially explain the recent downturn, as you can see, especially in the right-hand side of the map there. Now, this will become of note as we get to what is happening now under the Trump administration. But the interesting thing here is that foreign companies actually now get the thrust of all FCPA enforcement. When I used to talk on behalf of DOJ at various panels around the world and talk about enforcement, the question was always, well, is the FCPA a tool of U.S. foreign policy? And it was not. And I think the reason is U.S. companies, in part by nature of the fact that the FCPA was the first law, U.S. companies had to react first. We're so far ahead of others in terms of compliance. And foreign companies were now getting in the crosshairs because they were the ones listed on U.S. exchanges, subject to U.S. jurisdiction, but their compliance programs were not nearly as mature as we found in the U.S. And so in the last decade, you've seen the majority of cases brought against foreign companies, and really significantly, 9 of the 10 largest cases ever brought have been brought against foreign companies, Goldman and the 1MDB case being the outlier. And these are just U.S. sanctions. You can almost double those numbers when you talk about global penalties that each of these companies had to make. So all of this is to say what Brian will talk about now with the changes and what we see now with the Trump administration in the first 4 months, it's worth keeping in mind. The Trump administration is focused on advancing U.S. company interests and the national business interests in America. But one of the real issues here to understand is most of these cases have actually been against foreign domiciled companies. So I'll hand it over to Brian here to talk through what we're seeing now.
Thanks, Fry. So as Fry mentioned, February 5th, there was, Fry described one memo, but really there were 14 memoranda issued by Attorney General Bondi, all at the same time, that really attempted to align DOJ's enforcement priorities with President Trump's agenda. One of those memos in particular was focused on total elimination of terrorist organizations and transnational criminal organizations, which is a lofty goal for sure. And that memo in one part addressed the FCPA in a way that was sort of surprising to us and wasn't really all that expected. It deprioritized essentially all cases DOJ was working on that were not related to terrorism, cartels, or transnational criminal organizations. And it change some process, which, the details remain to be seen, but potentially could cause a sea change in how these cases really go forward. And that's that when you have FCPA cases, ostensibly only those involving cartels and TCOs, but could be more, that are brought, they can now be brought by U.S. attorneys' offices and not the FCPA unit at DOJ Maine. Additionally, they now only have to tell DOJ Maine 24 hours before filing charges. And so individual U.S. attorneys' offices now have the ability to run these investigations on their own and separately, whereas in the past, you were dealing with prosecutors who were expert in this area. They were used to these investigations. They were used to the international data privacy issues that would come up. They were used to the way the sort of process that had evolved over time of how outside counsel would conduct an internal investigation and information would flow back and forth and those sorts of things. And now it's decentralized. And so you have offices all over the country that have the ability to bring these cases. And in some cases, there could be conflicts. You could have a company being investigated by more than one U.S. attorney's office at a time. And so there could need to be advocacy to deconflict and consolidate and those sorts of things, but they're allowed to do that under the Bondi memo, which was not a process change anybody really foresaw. 5 days later then, President Trump issued an executive order pausing FCPA enforcement for 180 days. And he did this, the executive order sets forth some views that he had espoused over time, despite the fact, as Fry said, that enforcement had been very robust under the first Trump administration. He had made comments that he viewed that the law was stretched beyond the proper bounds and that it really harmed U.S. economic interests because he thought that other companies from other countries were not playing by the rules and U.S. companies were because DOJ wasn't forcing them to do so, that this was harming the economic interests of the U.S. So the executive order pauses enforcement. It directs the Attorney General to do a number of things in order to ensure that policies are aligned with the agenda. Weirdly, the Attorney General had already done that to some degree on February 5th with the memo, but the executive order came after that. It directs the Attorney General to do some specific things to reassess enforcement policies and guidelines, to issue new enforcement policies and guidelines, to pause investigations during the review, review pending matters to determine which ones investigations should be terminated, et cetera. It also specifically now requires that the Attorney General, even after that pause, approve all FCPA investigations. This seems to be in conflict with the Bondi memo of allowing individual U.S. attorneys' offices to pursue these cases and only to notify DOJ sort of at the last minute before filing charges. But the executive order requires the Attorney General to actually sign off on investigations. So how that is going to reconcile in practice in the future, we don't yet know. Because the clear focus and intention of the Attorney General initially was to decentralize and allow individual offices to do these things on their own. But then the executive order purports to centralize some of the decision-making back with the Attorney General. So this brings us to our first poll question for CLE credit. So how has your company's compliance function responded to the Bondi memo and the Trump executive order? And so there's different options: decrease in resources, increase in resources, tailoring emphasis, or no change. So we'll give a second for people to respond, and then we'll move on. It looks like we have a pretty strong majority so far. 91% responding have said no change. 2% have decreased, 3% have increased, and 3% have tailored their emphasis. So that's about what we would expect to see. The other thing that happened around the same time, if you've been following the news, in some small media outlets, there's been some stories about changes in the federal government and reductions in force and changing staffing and those sorts of things. And there had been a lot of talk about what this would mean for DOJ, as there had been for all other federal agencies and regulators, whether there would be mass reductions in force, whether those sorts of things would happen. Thus far, we haven't actually seen as much change at DOJ as we have in other agencies. So the SEC, for example, there's been public reporting of a large number of people that took the buyout offers and resigned. or probationary officials that were reduced in force, those sorts of things. DOJ, there has not been as much public reporting about that. We've spent some time talking to, contacts and former colleagues who are in DOJ, and thus far, we have not seen large changes in the staffing of the FCPA unit. We've also not seen the FCPA unit really being rededicated to immigration and other areas like some other parts of DOJ have been. And so thus far, the FCPA unit is still there, and people that we're aware of still seem to be, working on the FCPA cases that they were.
I'll say real quick, though, we've seen, obviously, there's been change at the very top of the criminal fraud section. And that is not, that the chief of the section has not yet been, the new chief has not yet been named. So there's still an acting chief who replaced the recent chief has been reassigned. And there's obviously been a lot of news about changes at the various U.S. attorneys' offices, which is natural in any change of administration. But FCPA unit, I think there was a lot of question, well, what is going to happen? And at least anecdotally and based on inside information that we have, you don't have a lot of people who have now been moved to the immigration sections yet.
Yeah, and yet I think is the key word there, right? If the one thing that we learned from the first Trump administration that certainly played out thus far in the second Trump administration is that things can change, right? On a random Friday, there's an email and suddenly things are very different. So it's unclear to the extent that the push for reduction in force, et cetera, are going to affect the FCPA unit itself. There have been some changes in corporate enforcement more generally. So as Fry mentioned, one of the rumors that was a rumor early on that ended up being true was the National Security Division's corporate enforcement unit was disbanded and the prosecutors were reassigned. The public integrity section was restructured and domestic corruption cases were carved out and given to the U.S. attorney's offices instead of those being now a focus of Main Justice. And the one thing that sort of reading the tea leaves we can see thus far is DOJ is still hiring for positions, but they are no longer hiring for the anti-corruption unit. And so they are hiring for immigration fraud and those sorts of things, but they are currently not adding to the people that are dedicated to anti-corruption. So that certainly tends to reinforce that there's a refocusing of priorities there.
On that point, we're seeing a lot of positions being made available, term positions, which is, again, not unusual, where you have a position for a 2-year, 3-year term to come into DOJ as a new prosecutor. But they're being specifically targeted towards enforcement in immigration work and in the border. So the border states, Texas being one, should expect to get a number of new prosecutors in the U.S. attorney's offices. And we expect that, though, to be almost entirely focused on these other priorities, not on white-collar priorities, notwithstanding some of the new guidance that came out.
Yeah. And we've as we alluded to, the differences in the unit and whether the FCPA unit continues to exist and continues to have sort of a centralized role, it's important for a number of reasons. From the company's perspective of someone that takes clients into the government and proffers and works through internal investigations and such, there's a real risk of losing the institutional knowledge that those prosecutors have about how these cases work and how they work in practice and how you need to investigate and how you need to get evidence from overseas and that you may not be able to get witnesses here and we may need to fly to London to interview witnesses and all those sorts of things. You may lose that institutional knowledge. And so particularly if it's decentralized to the U.S. attorney's offices, that could really drive up the costs of investigations, even though one of the stated goals of the pause is to reduce the burden of these investigations. The practical reality is that if that is the case, and certainly if you have multiple U.S. attorney's offices that are working on an investigation, it's going to actually drive up the complexity and the cost. There's also a risk of serial investigations, right? Where you go through with one U.S. attorney's office and you convince them that there's no there, and they stop, and then another office begins prosecuting and you have to sort of start all back over again, which we do see in some other cases, in past administrations where one office declines, but then another office decides they actually do want to allocate resources to that and they do want to proceed. And so, assuming jurisdiction and those sorts of things, there's a risk that there could be a divergence of offices and that the result, while intended to reduce the cost and burden on companies, could actually end up increasing the cost once you're actually before the government. I'll turn it over to Pete. He's going to continue on with some of the changes we've seen, and then we'll keep going from there.
I'll just double down real quick on one thing Brian just mentioned, which I do think cannot be understated. When you're dealing with corporate prosecutions, whether it's FCPA, antitrust, any of these areas, the fact that you're decentralizing going to the offices, shouldn't sound like necessarily a bad thing. You've got federal prosecutors all over the country who are fully capable of investigating and bringing cases. But corporate cases are different. There's entire policy memoranda. There's Chapter 8 of the sentencing guidelines solely dedicated to how to handle companies. And as someone who grew up as a regular line prosecutor before I got into corporate cases, I had no idea how those memos really played out in practice, or that, how companies, especially publicly traded companies, the risks associated with just normal document requests and how expensive they could be. And so there is real, as you said, institutional knowledge that could be lost. We don't know how this is going to play out in practice if it's not handled responsibly. And that responsible handling of corporate investigations is drilled down so frequently in the heads of those of us who handle those cases on the prosecuting side at DC. It'll be important, I think, frankly, for defense counsel now to really work with prosecutors if they're coming out of a local U.S. attorney's office on a corporate case and kind of guide them through, okay, thank you, here's actually what this means in practice when you're making these kind of requests. And this is why it could be counterproductive to what you're trying to do. And also why you should be able to trust us working with you to get you what you need in a streamlined way that can move your case faster. So it's a whole different conversation, but a really good point that I think should not be lost on us.
Yeah, and evaluating compliance programs is also a part of that, right? Is that there's been a push over the years of, we want companies to have compliance programs. We want them to have good compliance programs, and we'll defer to them in some instances. If things go wrong, we'll let the company off to a degree because they had a compliance program, those sorts of things. Now you're going to have prosecutors that are a lot less familiar with what a compliance program should look like and what some of the practical hindrances are, right? So it's easy to say we should all preserve ephemeral messaging, but doing that in practice is really, really hard. And so now you're going to be dealing with prosecutors who don't know that. It looks like we also have a question from the chat, which I think we could take now. How much appetite do you sense across the various U.S. attorneys' offices to take on cases that would be new for them, like FCPA cases? I'm interested in Fry's thoughts. My view is, for my colleagues and friends and such that are line level prosecutors, I think they'd be very interested in taking on a complex corporate fraud case if they're normally stuck on, drugs and guns and those sorts of cases. These cases tend to be a lot more attractive for prosecutors to take. So I'm interested in Fry's thoughts at the sort of policy level, but I think for the individual prosecutors, they'd be
I'm sure that line AUSAs would love the cases. They'd be fascinating, really interesting to work on. From a U.S. attorney who's going to actually make that decision, they're not necessarily a totally sexy case to take on. They take a ton of time to work up. You need to justify staffing. You need to justify funding from D.C. And if you're going to get a case that's going to end up in one stat or two stats for a resolution with a company and maybe a couple of individual prosecutions, but it takes you 4 years to get that versus the amount of time and resources that could be spent building and bringing cases that are admittedly higher priority, drug cases, gun cases, terrorism cases. Those are cases I think that management within the U.S. Attorney's offices are probably going to be pushing way more than one-off FCPA cases. Yeah. Having said that, certainly I think it will be an interest among certain offices to do so.
Okay. So like Fry mentioned earlier, after the executive order came out announcing the FCPA pause and before May 12th, we were trying to read the tea leaves with ongoing pending FCPA cases, prosecutions, investigations, as well as how DOJ has treated recently resolved cases from the last administration in an effort to understand what DOJ's approach might be before we get the actual policy that'll make things a bit more clear. The bottom line, at least currently, there doesn't appear to be a unified enforcement policy approach to how DOJ is handling these cases. Not yet. Again, after the policy comes out following the 180-day pause, that might change. But the current approach appears to be either case by case or possibly district by district, depending on the judgment of the U.S. attorney or acting U.S. attorney whose district the case is being brought in. So on the one hand, you have DOJ dismissed a years-long running prosecution of two former Cognizant executives. That case had been pending for 6 years, and it was dismissed mere days before trial. But on the other, you have other hand, you have 4 other cases the DOJ has expressed its intention to go forward to trial. Those are in the Southern District of Florida, Western District of Pennsylvania, and Central District of California. Interestingly, while the executive order talks about past FCPA enforcement harming U.S. competitiveness, several of the cases they're going forward to trial with involve U.S. companies and U.S. executives. And then while the executive order talks about the FCPA being stretched beyond its proper bounds, one of the cases involves alleged bribes, which are the gifts, travel, entertainment variety, which early on after the policy was announced, we were speculating internally about what the different statements in the order meant, whether gift, travel, and entertainment cases would be deprioritized rather than traditional wire transfers, monetary bribe payments was something we've been talking about potentially being a future direction, though currently, again, a case with a gift, travel, entertainment type alleged bribe is still pending. So those are all pending prosecutions against individuals. DOJ has also taken some action in pending investigations as well as already resolved cases, and we'll talk about those in a bit more detail shortly. So starting with the case against the 2 former Cognizant executives. This case was closely followed in the weeks following the executive order because this was the first FCPA case set for trial after the pause went into effect. Like I mentioned earlier, the case initially filed in 2019, nearly almost to the day 6 years later, the pause goes into effect while the case is set for trial in the coming weeks. The day after President Trump issues the order, the court orders the government to identify its position on the upcoming trial. In the days that follow, the government expresses its intention to move forward with trial following a prioritized review at the Department of Justice. The case is set for trial, but then the newly appointed U.S. attorney, I believe the day after being sworn in, requested a 180-day adjournment in order to review the case, notwithstanding the government's prior letter affirming that it was going forward with the trial. The court granted the adjournment, but not for 180 days, ultimately sets the trial for an April jury selection start date. But then just days before the trial is scheduled to begin, the U.S. attorney dropped the prosecution and cited the executive order as the reason for that. So interestingly, shortly after the criminal case closes down, the SEC moved to reopen a pending civil case that it had against the same defendants in order to, quote, explore a potential resolution. So in 2019, the U.S. government moved to intervene in the SEC's case, stayed it pending the outcome of the criminal case. And then in January of 2024, the court administratively terminated the case without prejudice, subject to the case potentially returning after the criminal case resolved. So the SEC restored the case, had a stay imposed by the court, and so there's potentially one more news day to come out of this as far as how the SEC either resolves or dismisses the case once it has finished the exploration it's talked about.
Or potentially goes forward with a trial. So this is going to be an important tea leaf to see because there is apparent incongruence right here in that one case that has been really, can't overstress the number of delays, 6-year-long case on the eve of trial and gets dismissed by DOJ. You'd expect the SEC to just go ahead and dismiss it as well, but they don't. It's still live.
Right. And so that is one case that involves 2 U.S. executives. These 4 cases are those that are going forward. Several of them involve U.S. business people, U.S. companies. They are across a variety of industries. The Zaglin case in the Southern District of Florida involves the sale of equipment to police in Honduras. You have the Bautista case, also in the same district, involving Smartmatic, which is an election machine company, dealing with alleged bribes in connection with the 2016 Philippine elections. And then the Hobson case in Pennsylvania is an executive for a coal company with alleged bribes relating to coal contracts. So those 3 cases all seem to fit the mold of your traditional FCPA case. You've got a business with executives accused of paying bribes in order to secure a secure business. The Diallo case is interesting because it's really more of a classic fraud case, an investor fraud case with an FCPA charge tacked on. But that charge is interesting because the charge is based on alleged bribes paid to foreign government officials in the form of a helicopter ride and providing vehicles for another official to use in a campaign in order to secure a land grant in furtherance of the scheme. So there's not really a clear underlying similarity between these cases or an explanation for why these cases would go forward when the other case in New Jersey did not. All those were individual prosecutions. And like I mentioned earlier, there have also been some interesting moves in corporate cases on the investigation stage, so pre-trial, and then the post-resolution stage. DOJ has terminated compliance monitorships that Glencore had imposed as part of a $1.1 billion resolution in 2022, even though it was only 2 years into what was supposed to be a 3-year monitorship commitment. Shortly after that, it let Stericycle out of its 2022 deferred prosecution agreement early. That was in April. It was set to expire in November of this year. So in both of those cases, DOJ has taken steps to unwind existing resolutions from the last administration and allow companies to depart from the obligations imposed under those resolutions early. There have also been several public announcements of cases being closed, so investigations being shut down. We list a few here. These are the ones that we found readily available in public information. There have been others. But the point here being that DOJ is closing down cases or allowing companies out of obligations from prior resolutions early where it's deeming that appropriate. All right. Briefly, I want to talk about foreign and state law enforcement reactions. So DOJ is subject to this pause. How are other countries, how are local enforcers reacting? So historically, DOJ and the SEC have brought most of the anti-corruption cases in history. Other agencies have become more active in recent years, particularly where they have partnered with DOJ or the SEC on transnational cases. But shortly after the FCPA pause, the United Kingdom, France, and Switzerland announced a joint anti-corruption prosecutorial task force composed of their key anti-corruption enforcement agencies. Now, we'll have to see whether that translates to increased enforcement. But at least they are making the statement that these other enforcement agencies want to have a more active role, particularly with DOJ being in a state of flux. At the same time, a couple of local enforcers have stepped up. Particularly the California Attorney General issued a press release stating that FCPA violations are actionable under California's unfair competition law. It'd be interesting to see how that plays out in practice. One thing we've noted, the executive order couches the FCPA and how it's been enforced in the past is impacting foreign policy. And before that, the Biden administration characterized it as a national security issue. Both of those could lead to potential preemption arguments for a company facing investigation by California. But it remains early. We'll have to see how those theories play out once they actually get tested. And while not FCPA specific, the district attorney in New York likewise said that that office would have a more active white-collar enforcement role as well. We'll see if other state and local enforcement authorities step up. So metropolitan DAs, state attorneys general, we'll see if they get more active coming forward.
Okay. And so this brings us to the May 12th policy announcements, and we'll run through those. I think just a couple of quick points before we hit those. On the SFO, the UK SFO, the PNF in France, and the Swiss prosecutors, keep in mind, the SEC, DOJ have brought about 75% of all foreign bribery cases historically to date. All right, the U.S. has been by far and away the largest enforcement authority. So that being said, there's been great movement in this space. There's clearly a reaction to what is perceived by a withdrawal from the space by DOJ and the SEC. And so, like Pete said, it remains to be seen how effective they'll be, but the desire is to be there. One interesting angle here we'll talk about now is also if the FCPA is now viewed as a tool to go after foreign companies, are these countries and others going to use it to go after and target U.S. companies as well? And that can lead to long investigations, expensive investigations, even if ultimately they're not as capable necessarily of building those cases or mature, at least in their prosecuting arms. A really good point on the federal preemption angle. If you ever find yourself subject to one of those state investigations, I think there's a number of ways to deal with those outside the typical playbook. So first, we'll go through the memos now that came out on May 12th and really spelling out the new approach to white-collar enforcement. The fairness, focus, and efficiency memo in DOJ's new white-collar priorities were set forth. There were 10 priorities listed. I'll get to them in a moment. In this first memo. It was released by the acting assistant attorney general, head of the criminal division, Matthew Gagliotti. And really, there were some common themes here. I'll say one thing is this. 4 months into this, the big question was, is DOJ purely going to be focused on immigration, on drugs, on cartels, terrorism? It was a bit of a surprise, number one, that we see white-collar enforcement being listed as a priority. And with so much emphasis and obviously so much time spent put into these memos. So it was really a message saying, look, white-collar enforcement is not dead. We're going to go forward and we're going to bring white-collar cases. What you see, though, is a lot of the same type of language, which Brian will speak to in a moment, kind of on the margins making changes and not the revolutionary shift that I think a lot of us would have expected, given so many bold moves in other spaces from the administration. The main thing I think takeaway here is the priority is going to be on what is identified as high-impact crimes. And really, that's focused on crimes where there are victims, crimes where there's violence. It's going to be where you see a nexus. One of the questions we'll talk about, I think, that has come through is what's the nexus with TCOs and foreign terrorist organizations. They're going to be looking for that nexus as they bring the new white-collar crimes. AML is an important area. So if you're dealing with financial transactions in Latin America that could be aiding cartel work, that is a big deal. This can be a focus. Obviously, anything in the Middle East that possibly could be going to hostile states there. There's a promise to streamline corporate investigations as well. Now, we've heard this. Every administration comes in, they say we're going to move these cases faster. I remember when now Judge Trevor McFadden was the Deputy Assistant Attorney General, just taken over in 2017. He said, we're going to move FCPA cases in months, not years. Well, they still lagged, and the average case takes well over 4 years from start to finish. So that's always been an aspirational goal. Remains to be seen if we can see actual movement here, but I would encourage anybody involved in an investigation, corporate investigation, to use these words in those conversations with the U.S. attorneys and the federal prosecutors, making sure that they are holding their feet to the fire on moving the cases forward and not letting them lag. The narrowing the scope of monitorships we'll talk about as well. And I mentioned, this is not signaling a slowdown in white collar. And in fact, it's signaling instead there may be new priorities that are actually going to see an uptick. False Claims Act cases, healthcare fraud, procurement, waste, fraud, and abuse style cases. And as I mentioned, AML. And then notably, Pete just mentioned a handful of cases where you had early terminations of DPAs and MPAs that have already occurred and monitorships that have already occurred. There's a specific directive here saying that fraud and the money laundering section, you are now to review all of the existing corporate agreements. So all the agreements the last administration entered into, fresh look. And there's a real opportunity because you may be getting an early termination if you engage with the department and really make the argument that this is not the kind of case that would be brought under the new administration, so additional resources shouldn't be spent on them. And we are working actively on cases like that right now to try to take advantage of this. What are the high impact enforcement areas? So they're listed here, healthcare fraud, trade and customs fraud, tariff evasion, customs evasion. We have elder abuse, market manipulation cases, sanctions, cartel, material support of terrorist organizations, the kind of things you'd expect that can now be brought also against companies. And you focus on China, so Chinese money laundering, that can take place in the IP theft realm, that can take place in the just counterfeiting realm. We see a lot of those types of cases. So financial institutions, MSBs that may be involved with a lot of transactions to China should be taking a close look there. Fentanyl remains high in very important opioid cases. So dealing there with people in the healthcare sector, companies in the healthcare sector. And then, interestingly, the FCPA and the Foreign Extortion Prevention Act, a new law passed in 2023, focusing on foreign bribery, where it's the demand side, the officials, and the folks with their hands out, being potentially a new and more important target of investigations, and money laundering associated therewith. And then digital crimes. Now, interestingly, this has been viewed as the most crypto-friendly, digital asset-friendly administration to date. That's how they're being positioned. A number of those cases have been dropped. And they're really focused on those cases where crypto is being used as a means to defraud investors. So they really want to look for ones where they can have easily identifiable victims, not so much regulatory securities types of cases that result. The one thing I want to mention, there's an op-ed I wrote, there's copies of it here, we'll make it available afterwards to those attending online. But I published an op-ed in The Hill really talking about, well, what does an America first foreign policy agenda look like in the FCPA space? And notably, FCPA, notwithstanding the pause and notwithstanding the May 5th memo, is listed as number 9 on this, foreign bribery cases are listed as a number 9 on the priority list. And, that's an important tell. I think we're still going to see guidance come out after this 180-day pause is over. But the FCPA is not listed purely in TCOs, transnational criminal organizations or cartels. It's a broader view of what impacts national security, the markets, and also what impacts in lining the pockets of foreign officials. So what does that mean? It could very well mean a focus on foreign companies in the FCPA space. So it could be broader than what the May 5th memo suggests. It could also mean that you're focused on foreign officials. So historically, the FCPA never had a law criminalizing solicitation of bribes. It was only the supply side, not the demand side. Now, is it going to look more of using the FCPA and other laws to go after the bribe solicitors to create a clean marketplace for all companies, including U.S. ones? Are we going to see potentially really robust opportunities for voluntary self-disclosures in FCPA cases? And I mentioned this, and it's something I spell out a little bit more detail in the op-ed. While focusing on the demand side, one thing that could be made available, and we'll see what the guidance holds true on this, is if you find a problem, can you go in and actually get that resolution within days or weeks or months and not years? And the promise being not a huge penalty, not disgorgement of profits, but actually, I'm going to cooperate and help you build the case against foreign officials. That's the consideration. And if you were to enter into a non-prosecution agreement along those lines, you're able to then use that as a shield against the next administration that comes in that takes a different view of FCPA enforcement and against those foreign authorities that may be trying to attack, because that kind of an MPA would actually have res judicata effect in those types of cases. So if you're in the middle of this and you find yourself on your compliance side identifying a problem abroad, that would be an FCPA case. There could actually be a real opportunity here to negotiate a very good resolution that could be used also as a shield against other authorities there. Yes. Yeah.
What good is the enforcement of the demand side when the long arm of the United States government may not reach those that are found guilty of bribes? It seems more efficient to go on the supply side because these are all companies that have a tie to the United States.
Well, historically, the number of officials have been prosecuted, and they've been prosecuted. So the long arm is very long. And if you're actually, historically, money laundering laws have been used, right, with the FCPA as a specified underlying offense to get there. You're using US dollars, so that has, DOJ has taken the view that that opens the door to jurisdiction. Is it harder to go after those officials? Yes, because they're typically located abroad unless they fly into the States. But it's, I think, the threat of that enforcement, the exposure, the fact that what ultimately happens if you're in a hostile regime and or a regime that doesn't isn't going to be necessarily mutually working with the U.S., China, Russia, former Soviet states. What ends up happening is they get boxed in. So they can no longer travel internationally without fear of an Interpol notice and potentially being brought to justice. The FCPA really just adds a new tool and a more robust tool with higher penalties. But is it more or less efficient? Look, it's certainly, you can argue that it's less efficient, but my point is simply, if the new administration is going to take this America First approach, that is a way that they can do so, and also that companies can avail themselves in a way to take advantage of that. So let me move on. I know we have a few minutes left, and we got to run through the changes to the corporate enforcement policy, and we'll do that here.
Yeah, thanks, Fry. I will run through quickly the changes to the enforcement policy. We were going to hand back off to Pete, but Pete, I think I'll run through the whistleblower and the corporate monitorship to keep things moving. The corporate enforcement policy came out originally in 2015 in the AIDS memo, and there's been evolution since then. I think the important takeaways from the most recent changes are that it's really a difference without a distinction. So the language of the old corporate enforcement policy was effectively that if you self-disclosed and you cooperated, there was a presumption of a declination. The new policy says there will be a declination, but there are still a lot of vague areas and squishiness where prosecutors determine whether you really did report in good faith and those sorts of things. There's still graduated incentives that have been tweaked a little bit, and so if you disclose and if it was a good faith self-report, but not a voluntary self-disclosure, meaning we say the government already knew about it, there are graduated reductions off of it, incentives, those sorts of things. There is now a helpful flow chart for the first time, a somewhat helpful flow chart, I guess, which makes this a little more clear. It illustrates, though, that really the points are, whether you're really in the yes column is really going to be advocacy before the government. And so even though it now says there's a declination versus a presumption, there's still plenty of outs for the government to say you don't get a declination. The important parts are, you need a self-report. It's got to be, the government has to really have learned of it from the first time from your self-report. You have to cooperate. You have to make witnesses and evidence available. You have to explain to the government why, if data privacy laws don't allow you to do that, you're doing that. You have to remediate. And then there's a question of aggravating circumstances, as there was before. And so really, this is just tweaks around the margins, but really doesn't change anything as far as enforcement is concerned. Importantly, under the new policy, even if you get a declination, you're still required to pay disgorgement, restitution, and there's obviously still the chance for negative publicity. And so those were all the same under the old one. And so in reality, there's not a ton of change here. We do need to go through a couple more polling questions for purposes of CLE credit. So I'm going to have them put up the polling question now about whether, based on this, your changes, your company is more or less likely to self-report. But I'm not going to wait for the responses. I'll give you the responses so we can keep going. The whistleblower policy was also updated. The most important takeaway probably for companies is that FCPA, money laundering, FCPA is still listed as one of the covered areas and in fact is number 2 on the list, right? And so again, this just shows that while the focus of those cases may be changed slightly, corporate white collar enforcement's not going anywhere and the whistleblower program remains robust to encourage whistleblowers to go to the government. Corporate monitors have been deprioritized extensively by the government. And so while we saw in the past that monitors were imposed in a lot of cases, now the policy is essentially that corporate monitors will be the exception and not the rule. And when corporate monitors are imposed, there'll be more close monitoring controls on their costs by the government to ensure that they're not growing into these extensive things that would be very expensive. Again, what that actually means in practice, we'll see. The implications for corporate compliance programs. So what does all this mean for you? Our key takeaways here are that the government, DOJ, has provided a blueprint of what their focuses are right now. And as we've alluded to here, it prioritizes different things than in the past, including immigration and material support to terrorist organizations. This brings me to a question we got about, can you please elaborate on the nexus between the FCPA and TCOs and FTOs? There are two cases that come to mind in Lafarge. It was a cement plant in Syria, and they were making payments to ISIS in order to operate their plant. And so ISIS is obviously a foreign terrorist organization. It was actually set up as a revenue sharing, and they even had ISIS effectively try to prevent Turkish cement from coming into the market, so they had a better share. And so that's a case, you can have a nexus there. Chiquita was in 2007, and they were paying for protection in Colombia, in fact, over the advice of their outside counsel, which became public, and the organization they were paying was designated. What's important here and where this is really to become relevant to you all is that drug cartels have now been designated foreign terrorist organizations. And so, for example, there's State Department reporting from a few years ago that says about 6% of Mexico's GDP is related to narco trafficking and the drug cartels. And so when you're in Latin America and you're doing work, even if you're doing work legitimately, there is a significant risk that you're doing business with companies that are owned by drug cartels that are operating in order to layer the money. And there are also parts of Mexico, again, as an example, where drug cartels effectively run the local government, either because they're elected officials or because they control the elected officials. And so when you're doing business there, there's a significant risk that you can be seen as providing support or facilitating those drug cartels, which are now foreign terrorist organizations, right? And so what the overlap will ultimately come out to be in practice is unclear, but it's certainly a new risk area.
I'll say that Chiquita case is so similar to what the way that Colombia was in the 90s and 2000s is very similar to what we see in Mexico right now. And so companies that are operating in large sections there have those same risks. The FCPA is frankly the least of your concerns now. It's material support of terrorism that it carries much bigger fines, much bigger criminal time, and something everyone should be, I think, wary of, both on the AML side and just if you have any business operations in some of those regions.
Yeah. Our view, focus on the FCPA. You now have other areas to add to your compliance program, but anti-corruption isn't going anywhere. As Pete talked about, other international enforcers are still out there. The statute of limitations is either 5 years or 6 years, depending on the offense you're talking about. It can be extended up to 9 years, and DOJ typically considers these to be ongoing conspiracies, so the statute of limitations doesn't really start to run or doesn't expire. And so the result being is that conduct that occurs today could be evaluated by the next administration's DOJ. That's the important takeaway there. And so you really can't back off compliance in those areas. Practically, companies have also been signing agreements for years that says they will comply with the FCPA, whether DOJ is enforcing it or not. And many of those clauses do specifically require you to maintain effective compliance programs as part of that. And so there's a real practical commercial risk of cross-defaulting under all sorts of agreements if you were to really back off anti-corruption, even if it's not DOJ's principal area of focus right now. So in our view, now is really the time to double down on compliance, right? Risk assessments need to be redone because now you've got other risk areas you need to look at. You need to look at, drug cartels and whether you're potentially exposed to them in Latin America. You need to look at tariffs and sanctions and how those issues are affecting your company and how you're tracking, there's new things every day. How are you tracking those? And we've worked on some cases where, a product was ordered, it was shipped, it was put on a pallet, and the sanctions changed before it was put on the truck. And is that a violation that needs to be self-disclosed or not, right? Those are all risk areas that companies now need to think about as part of their compliance programs. We do hope and expect there will be additional guidance in coming months. We expect there will be likely, potentially abrupt additional shifts in focus as the administration continues, as new policy things are announced. The focus of DOJ will change to reinforce those in focus. That could be frustrating for companies, but compliance programs need to be broad enough to do that. The other practical point is, and then I'll turn it back over to Fry, is that if an issue arises in the future, whether it's 3 years from now or 5 years from now, 7 years from now, any prosecutor is going to look at what you're doing right now where you don't have DOJ breathing down your neck to understand whether you're really committed to compliance or not, right? This is a natural area for them to come back and look what you did during this period to see whether the company really was committed to compliance. And so, again, risk assessments, You may need new or additional compliance resources because of those new risk areas you need to focus on. You need to consider how you're allocating your compliance resources for sure, but this isn't, there's been nothing thus far that suggests that, corporate compliance is no longer as big of a priority as it was. Polling question 3, does your company intend to conduct a risk assessment or shift compliance resources? And I will move on to Fry.
And want to see those answers, which is important. And just a quick thing, the last result was upwards of 85%, I think, said that the new CEP changes would not influence the ability to self-report. I think that's probably right. Really didn't move the needle all that much. Here we're seeing about 2/3, no, we don't anticipate doing any risk assessment, about 1/3 saying yes. I will say, I can't emphasize that enough, and something we obviously can talk about. Feel free to reach out and we can share our thoughts. We do these types of risk assessments, but I do think generally, whether it's us or otherwise, companies would be well advised to do that. The final thing, I'm not going to take any more time. Talk with us afterwards. You have questions, please reach out. The opportunities for proactive engagement now, if you are under investigation or that began under the Biden administration, if you had a case that happened that you're possibly under an MPA or DPA right now, you're doing malpractice if you're not affirmatively looking for ways to engage, because there's opportunities to get those cases terminated early. As I said, we're helping with some of those at the moment as well. And on the self-reporting, as I said, be aware for new guidance that might make that more of a sweet carrot to take advantage of. The last point I want to say, we've written about this in the past. Victim claims for restitution from companies are the best cases to bring. And if you are a U.S. company and you can show that a foreign company has actually gotten a contract in an emerging market and you had clean hands and didn't, now is actually the best opportunity that probably presents to potentially turn the compliance side actually into a potential revenue generator, because you can make those claims. We wrote an article about this multiple times. One actually was also on the Ericsson Nokia settlement. Didn't get a lot of news at the time, but ultimately after the Ericsson FCPA agreement, paid $93 million to Nokia because they had a claim like that. It was only reported publicly in their filings, but those examples, I think, if you're being smart about things, those opportunities will present. Happy to talk through later. Here's our information. Bios are also at the end of the PowerPoints. Really appreciate your time. Sorry, went over, but I appreciate everyone coming today and attending online. Thanks.